Welcome everybody to the Vocational Science of Freedom Totality of Law online law class, where we'll cover all of the aspects of law, what the law is, its different types, its different jurisdictions and kinds, and different courts. All of the downloads for today's class are on the Mega Download site, which are linked onto the March VSOF day class. This particular room, the March VSOF day class, will not stay up forever. However, everyone here should make sure that they bookmark the Mega link so that they always have access to the documents, and make sure that you download all of them. The folder will not go anywhere. The Mega link download folder will not go anywhere, but this class will not. This classroom on the Vocational Science of Freedom Gilded server will not stay up indefinitely. It'll eventually go to April and then May. So, just to make note of that to everyone. So let's start by opening up the March Totality of Law class outline 1.0, and if you have downloaded the whole folder onto your hard drive, it should look like this in the beginning, and then under the handouts. So there's two things that I'd like everyone to open up, and that is the outline and the map of the kinds of law. And I'm going to expand it out a little bit, and then I'm going to move it over to the side as best I can, and I'll open it and close it throughout the day when I am specifically talking about various different parts of this outline. This outline is something that I just created literally yesterday, because I realized that I had never looked at and thought about where the different types of law overlap. So just make sure that you've downloaded at least the outline and the map, and then we'll set these two things aside, and I'll get to the map later. But just make sure that you have the capacity to have it open and ready, because there'll be a lot of discussion that goes back and forth between the map and the outline for today. So let me put that off to the side. And okay, so before we begin, the aspects of how to learn the law is something that has taken me a long time to figure out. 25 years. And probably the first 15 of those years I was fumbling around, not being absolutely sure what I should be looking for, or even when sometimes I did come across something, I wasn't even sure how to categorize it. And the reason is because, clearly, as you can see with the law map outline, a lot of these things overlap, and it gets ridiculously confusing. Now, of course, there might be some of these lines that I might have that might be off, but I honestly, in 25 years of studying law, I think I have this whole entire map correct. So the circles are the various different either kinds of law or jurisdictions or divisions, which we'll get into what all those are. The main divisions between natural and positive, and the classes: natural law, law of nations, public law, private Roman civil law, the origins of law, common law and statutory, and the 5 different jurisdictions. But just to start with here, the circles are aspects of law or kinds or types or jurisdictions, and the squares, the boxes, are the different kinds of courts. So I know that some of these are ovals and not circles, but I had to do that to be able to fit them in to what overlapped where. So anything that's a square, or sorry, anything that's a circle or an oval is a type or kind of law, and then everything that's a square is a type of court. So just so you know that. And the only thing that I did slightly overlap, or that was slightly impossible to not overlap incorrectly, was the inferior courts not of record. The inferior courts not of record do not have anything to do with natural law, and they have nothing to do with common law, which is why the line stops here. But I couldn't really bring a line in between here and here to not touch these two circles based on where I had everything situated. Perhaps at some point in time, I may develop a full PowerPoint presentation where each of these circles is placed one at a time and overlaps, and I can explain it one at a time. But I'll do as best I can to show you guys through the outline and going back and forth between this and the map today how all this is laid out. And and not to praise myself or anything, but I honestly, not even thinking about ever doing this before, I've never seen a map like this before that would explain what it's taken my brain 25 years to try to work out as to how all this does fit together. So you guys are getting the only map that I've ever seen to explain everything that'll be in the outline and everything that'll be in all of these treatises today for the first time, because I don't know that a map like this even exists. So with that, let's get to starting with the proper dictionaries. So the two major different kinds of dictionaries are common law dictionaries and then basically Maritime Admiralty or the Law Merchant. So Maritime Admiralty deals with banking and merchant affairs. So this is the turquoise, I guess, color, if you will. So Maritime Admiralty law. And Maritime Admiralty law and the Law Merchant have a lot to do with each other. They're very closely related, as does Roman civil law have to do with both of them. So you have Roman civil law that encompasses both Law Merchant and Maritime Admiralty law. And then the UCC is a sect of basically all four of these, or actually five of them: Law Merchant, Maritime Admiralty law, statutory law, Roman civil law, and positive law, because positive law is just every man-made law. Okay. And the two different types of dictionaries you're going to have are in between those two. So the main dictionary that you want to always use for anything that you're going to be doing in your courts of record, and anything that has anything to do with the federal constitution or the state constitutions, you should look up in Bouvier's Law Dictionary. And this is the entire title of it. The 1856 edition is the best edition that I think has ever been. And there's 3 separate acts of Congress even that tell Congress and all of the United States federal corporation, which we'll get into later, but even the aspect of all of the foundational documents of the republic, that by 3 acts of Congress, that's the dictionary that you should be using to deal with constitutional matters. So the name of it is A Law Dictionary Adapted to the Constitution and Laws of the United States of America and of the several states of the American Union, with references to the civil and other systems of foreign law. Every time you see the word civil law, it's always in reference to Roman civil law. Always. Civil, Roman civil. It's exactly the same thing. They're never separated. So civil law is always Roman civil law. And that's why it says that in this dictionary, adapted to the Constitution and laws of the United States of America, that the civil law is foreign to you. Always will be. The only way you get stuck in this mess over here is by consent or contract. And some of the mess you get stuck in down here is from a standpoint of a contract of joining the military, but that's for another reason, of course. This is, you know what you're doing when you join this contract, or at least you should know. All this mess up here, a lot of people enter into without knowledge, and to their detriment, always. So that's Bouvier's Law Dictionary. And everyone, you can find the entire copy of this law dictionary on this mega link, which is part of the Vocational Science of Freedom free online law library, which everyone gets to have for free. That's simply on the VSOF Gilded server. And so you can look at the links there, and on the Gilded server, the online law libraries are under the reference section for law libraries here. And that's also where you can find the other links, along with many other links to other law libraries that are not things that I've put up, but we also have links to and other people have found over the years. So a lot of the definitions I'll be taking and talking about today will be coming from Bouvier's, but some of them will be coming from Black's or from other references of law, mostly treatises on law. So, and with that, the foundational starting books everyone should start with have not changed for hundreds of years. Blackstone's commentaries, which in Blackstone's commentaries in the handouts, it will be under foundational starting books. So it's under handouts and then foundational starting books. And I've given everyone several different copies of Blackstone's commentaries. There's the entire Blackstone's commentaries here, which is the commentaries on the laws of England. That's what it'll look like when it pops up. And then there is the the Blackstone commentary books, these ones, the online law library of liberty, what these people did is they took all of Blackstone's and they basically put it into text. Now, some of the pages obviously are still original, but they put the rest of the pages into text so that you can not only easily click on something. So say if you wanted to know about Guardian Ward, you just click on it and it'll instantaneously take you to that section. This is a very, very good set because they did this. I have no idea who did it or how they went about doing it, but obviously it took a lot of time. So I commend whoever it was that worked on this project to do that, because it saves a tremendous amount of time to look for things in Blackstone's. Now, just to give a little bit of background, Blackstone's commentaries, the publication of this particular one is 1893. I'm not exactly sure when the first one was. It might be in here, it might not. Oh, okay, yeah, 1753. So it's been around for quite a while. And in the colonial days in America, what everyone had pretty much for a reference of law, the two books, was the Geneva Bible and Blackstone's commentaries. And there were more copies of Blackstone's commentaries sold in the colonies than there were in England. And funny story about that, there was a English judge of the Admiralty Court who complained basically to the king and said, during the day, or no, sorry, I think it was during the night, the colonists destroy our property and raid our stores, and during the day they acquit everyone in the grand juries. It is impossible to uphold the king's law because every American is a lawyer. And lawyer means know the law. Does not mean an attorney. And I'll get into the definition, but what the difference between attorney, a barrister, a solicitor, and I'll get into all that today. But just for now, as far as the quote is concerned, a lawyer is just simply someone who knows the law. So I would consider myself to be a lawyer. I would consider all of you to be lawyers because you know the law. And certainly after today's course, you will certainly know a lot more than hopefully you did when you started out the day. And you'll probably know a lot more than the vast majority of attorneys and judges that actually sit on the bench, because the studies of the thorough studies of the law that are in Blackstone's and some of the other foundational documents and treatises, which I'll show today, are simply not taught in law school. They, particularly a lot of the aspects of the common law has been just absolutely eviscerated. It was the major aspect of all of colonial law as far as how things were run. But of course, banking, influence, and attorneys who deal with and who are members of the British Accreditation Registry, the Bar Association, they all deal with everything over here under the merchant law and law merchant and Maritime Admiralty. And now UCC, which is a global aspect of these two things in statutory and Roman civil law put together, which now it's a global law merchant system is what the UCC is. So in them wanting to get rid of the common law, because the common law was controlled by us, it was controlled by the people, and it was adjudicated in courts of record instead of the rest of these other inferior courts, which I'll get into later on today. So that's Blackstone's. And another foundational document, or another aspect of foundational law, is basically anything else written by John Bouvier. He did a lot more than just write this dictionary. So what I did was I tracked this down off of archive.org. And this is a 4-volume set of Institutes of American Law by John Bouvier. And it took me a while to find this on archive.org, but I'm very glad that I did because of the thoroughness of his work and what this document is. This is just all the abbreviation, so I'm just going to skip forward until we get to so I can show you guys the table of contents here. So, and I know this is going to be a little small to read. I'll try and blow it up just give you an idea of just how thorough. I'm not going to read the whole thing. I just want to give you an idea how thorough this is and how important it is to understand where John Bouvier, how he wrote and how he put these things together and how he saw American jurisprudence and the difference between American jurisprudence and English jurisprudence. Okay, so just from the start here, right off the bat, our of laws in general, which is what kind of this whole entire whole day course is going to be basically this part of this book of laws in general. We're going to be discussing everything about the totality of law. So of justice, of laws, of the laws of nature, of the laws of nations, of municipal law, of sovereignty and different forms of government. What is sovereignty? Now, that's a question right there. What is sovereignty? You're never, ever going to even so much as start a conversation with an attorney. It just won't happen. They'll say the judge is God, and they'll say the government is the only sovereign, period, end of story, and you're a subject, and that's the end of it. Well, you're going to find out through case law and through the history of today that is absolutely incorrect. We, the people, are the sovereignty of the nation states, which are the Union States united. But again, I'll get into that, into the division of what the United States of America is, and the United States is, and the United States Incorporated is, compared to the States United and our status. But just for now, just to continue on here. So he starts out with how the powers of sovereignty are divided, and then what is a constitution? There's a whole aspect of what is constitutional theory and what is a constitution, which most people don't even realize the totality of what that is in itself. And then we have different forms of government, different forms, the government of the United States, the history of its information, by whom the sovereignty is exercised in the United States. Notice that. That gets into the aspect of grand juries. Grand juries and petite juries is how we, the people, exercise our sovereignty, both on the state and federal level. Because remember, the federal level is just a trust between the sovereign states. And the only reason the sovereign states are sovereign is because we, the people, are sovereign. Not because the entity itself, the uppercase S state, is sovereign. The people are sovereign. And that's what makes it a republic. Okay. So, as I said, I'm not going to read all this, but just give you an idea of the totality of how John Bouvier's law books are written. And obviously this table of contents goes on for quite a while, and this is just book one. But it's very easy to look up something and follow something. Oh, and one other thing about the study of law. Regarding any digital document you have about law, all you have to do for any PDF document is hold down Control and then hit the F button. And it'll bring up the find here. And all you have to do is just click in what you're looking for. And so if you want to learn about, say you want to learn about common law, right? So you just type in common law and then you hit next. And it'll take you to the next place where the term is. So statutes in derogation of the common law are to be construed strictly. Now that's an interesting statement that came up just on the search, right? So statutes. Any statute that is something against the common law or an opposite of the common law are to be construed strictly. They have to be, you have to use them exactly the way they're stated. They cannot be broad. You cannot expand their meaning. Okay. And that's because the common law is the superior law. And so then you can just click it again and go through and find various different things of anything you're looking for, right? So just a note to anybody who's new to that search aspect of a PDF. So that's John Bouvier's American Laws in 4 volumes. That's Blackstone's for you. And then the other one here is a book which a gentleman by the name of Richard McDonald, who has some good lectures on YouTube, suggested that this was the book to read. And also this book is also very well laid out. I've also gone through it and looked through and also found some of the parts of where he was specifically talking about. He says in this book, it's interesting to read that the difference between the aspect of this, the state and the different members of a state and the sovereignty, that there's a huge difference. And they do make it very clear in here, the difference between a de jure state citizen or more importantly, one of the people. I always say one of the people in all of my paperwork. I stay away from the term citizen as a general rule, just because it's been so corrupted and used to manipulate and control people instead of being what it's supposed to be, which is just a definition of a word of being proud of being part of the country of what you're connected to. But when you say I'm one of the people of, say, the state of Michigan or the state of Illinois, you are stating, if you do it verbally, you're literally stating the fact that you are sovereign. And also, you're also stating it in the same way on any paperwork that you might file for court. You say, I am one of the people of, or comes now one of the people of Michigan, right? So right there, you've established your sovereignty. And in this book, it's very clear the difference between a de jure state citizen and a citizen of the United States, right? And it's also a very good book. It's very easy to read. The sections are very easy to follow, and it also has a good part of it regarding procedure, right? Common law procedure, common law actions, common law procedure, equity procedure, code procedure. Interesting how these are different, right? So common law actions, equity procedure, and code, which means this is statute, right? Codes is statute. And criminal procedure, a lot of this is under statute now too. These are all different things. Well, whatever happened to the common law, and even as far as that's concerned, whatever happened to equity either, which is kind of an aspect of fairness under the common law, but we'll get into that later. Where did these go? Well, the attorney doesn't want them around anymore, right? And of course, what to tort, and then the remedies, and so on and so forth. So this is another very, very good. If you were going to sit down and read 2 books, just 2, and go through them completely, and take every single word that you do not know the meaning of, and look it up in Bouvier's Law Dictionary as you're reading them, it should be this book, The Elementary Law, Smith, and Blackstone's Commentaries. If you do that, you will know the totality of law, pre the attorney destroying it, and pre the New Deal of 1933, where they started to remove common law courts and said, you don't have title to your property and your land anymore, and we're going to administer you as an infant for the rest of your life. So pre the destruction of the common law, you'll get all of the information as to how things are supposed to be run, and how they were run, and how they should still be run, by reading these 2 books and understanding all the definitions therein by double checking them in Bouvier's, or if you like, you can also double check them in Black's when it deals with the aspects of the laws not dealing with common law, meaning all the mess of spiderweb over here. Okay, so those are your foundational things. Oh, one more thing I was going to show you guys about if you want, in other research, there's 2 other books in here, which I highly suggest you take a look at. One is From Sovereign to Serf, Roger S. Sales. This was done, I don't know when this was done, 2011. So it's 267 pages. And this has been a slow boil of the frog, right? So that's a good one to read. My 1215.org folder, I created a document, and I and another colleague of mine a long time ago created this document. What we did was we took everything out, all of the various different documents that Bill Thornton had put up onto his 1215.org site. And what we did was we turned them into one single document that's 70, or actually I'm not, hold on. Looks like it's 82 pages. So what it is basically all the various different teachings that Bill has put up on 1215.org, all in one document. So you can just read it straight through. And they're all with the same headings. Nothing's been changed. I haven't altered anything. Everything's exactly how it is on his site. So all praise to Bill and for all his work over the decades that he's done to give all of this information to all of us for all of our benefit. So that's Bill's. And then this document, one last document, the Psychology of Persuasion. This is nothing to do with law per se, but I wanted to give everybody this so that you understand anytime that you ever get into a fight with a judge, I want you to understand how to win from the standpoint of the various different laws of persuasion. And I'll just try to get down to the list real quick here and just show you what they are, because I want you to understand some of these things about how they manipulate us, right? So I don't know if there's I think there's a complete list at the end of this. They go one by one here. Hold on. Let me get to the end of it. Because there's one called the law of power, which is extremely important, which is the one that the judges use all the time against people. And if you know what it, yeah, right here, if you know how this works, you can be aware of it at any time. It's basically, what it comes down to is the fallacy of authority. So the law of power. People have power over other people to the degree that they are perceived as having greater authority, strength, or experience. Now, when it comes to a judge, you walk into a court, you think, oh, he's God. And the attorneys are even trained that he's God in law school. They say, okay, the judge is a 500-pound gorilla, and if he screams, give him his stupid banana, right? Well, he's just a man. And the point is that you should never let this aspect of the law of power, this aspect of psychology of persuasion, to ever alter what you're doing in your court of record. Always know that when you open a court of record, you're the sovereign in the court. He's just a magistrate. He has no power whatsoever. And I'm going to scroll down here and see if I can get, okay, yep, I think here's all of them. Okay, I'm going to read all these just really quick because these are important. So the law of reciprocity. When someone gives you something of perceived value, you immediately respond with the desire to give something back. Okay, that's normal, that's natural. Nothing wrong with that one. Law of contrast. When two items are relatively different from each other, we will see them as more different if placed close together in time or space. This is how attorneys get everybody to do plea deals. Well, if you just do this plea deal, we'll only give you 4 months. But if you don't do it, you could go to trial and you could take, it might be 10 years of your life. Right? That sounds drastic when put that close together, right? So what are they doing? They're using the law of contrast against you. Law of friends. When someone asks you to do something, you perceive that person to have your best interest in mind, and or you would like him or her to have your best interest in mind, you are strongly motivated to fulfill the request. What do attorneys use for that? Well, I'm your friend. I'm here, and actually they're called, in a lot of times in aspects of law, there is something called a next friend. So basically the attorney is acting as your next friend in these inferior courts. And what he does, he says, well, I'm your friend. I'm here to help you navigate this spider web of monstrosity over here. I'm here to help you. So, tell me this and pay me this and pay me this and pay me some more and pay me some more. And, oh, you still got to pay me some more. Never let an attorney make you believe that he is your friend, ever. Law of expectancy. When someone whom you believe in or expects you to perform a task or produce a certain result, you will tend to fulfill his expectation, whether positive or negative. Law of expectancy. Again, this gets back to the aspect of a judge. It gets back to the aspect of the fallacy of authority in general when you're dealing with cops, right? Oh, you have authority. Well, get out of the car, please. Huh? No. Law of association. We tend to like products, services, or ideas that are endorsed by other people we like or respect. This doesn't have much to do with law, but it does have to do with the corruption of society through Hollywood. Law of consistency. When an individual announces in writing or verbally that he is taking a position on an issue or point of view, he will strongly tend to defend that belief regardless of its accuracy, even in the face of overwhelming evidence to the contrary. They use this against you all the time in courts because if you don't stay consistent, they'll throw out all of your testimony, which you can also use this against a cop too. I've heard of a ridiculously easy way to dismiss all testimony of any cop on the stand. You ask them some question about or maybe about the issue, or say if it's traffic. Did you pull me over on such and such a day? They'll say yes. They'll say, and then you ask them, are you here today on your own volition? And they say yes. Then you go back to something dealing with the traffic. They'll say, is my car blue? Yes. And then you ask them, are you under subpoena today? And they'll say yes. And because a subpoena means that they're there by order, not by their own volition, and they answered yes to the fact that they were under their own volition 2 questions earlier, you can throw out their whole entire testimony. And almost every single cop will fall for that because they are just too stupid to know different. And technically they have to throw it out because they didn't stay consistent with their testimony. And so therefore inconsistent testimony is grounds to dismiss the entire testimony, to strike everything. So anyway, I'm getting a little bit into process, but that's an important thing that I thought everybody should know. Law of scarcity: when a person perceives that something he might want is limited in quantity, believes that the value of what he might want is greater than if it were available in abundance. Yeah, like your freedom. Law of conformity: most people tend to agree to proposals, products, or services that will be perceived as acceptable by the majority of other people or a majority of an individual's peer group. Right? Law of conformity. Well, you walk into a traffic court and you see 250 people walk up there like sheep, pay the fine and leave. What's your tendency going to be? It's going to be to do the same thing. There's going to be very, very few people, maybe 2 or 3% of people, which would even stop and say, wait a second, what's going on here? And then there'll be an even less percentage of those people that will actually do something about it. So, law of power. And then that's when I said before, this has to do with the judge. People have power over other people to the degree that they are perceived as having greater authority, strength, or experience. The judge has nothing over you because no judge in any of these filthy inferior courts have any jurisdiction over you except by your consent. Now, even if they say, well, you signed a contract, say, really? Produce the winning signature contract. Produce it. I deny that I've ever signed a wedding signature contract. And then they would have to go and produce it right then and there, the wedding signature contract, which of course they don't have. They don't even have it for mortgages, because what they do with that is they go and they shred the damn thing. And then they put it into mortgage-backed securities and so on and so forth. But I digress. The point is that it has to be by consent. There's no consent. And even if you did produce a contract, it wouldn't be a lawful contract because there's no lawful consideration in circulation, people. Federal Reserve notes do not have lawful consideration backing it. They're worthless. So anytime you use them for a contract, that contract is null and void, which is why I asked to get paid in silver, which is why we should all start using silver to do exchanges with each other and your local grocery store, as far as I'm concerned. So anyway, those are the 9 laws of persuasion. I suggest that everybody read the rest of that book. It's a very interesting read, and it will pretty much stop anyone who is attempting to persuade you in the wrong direction dead in their tracks, because you'll know what they're up to. One last note here about foundational documents. Most of the greatest books on the common law will all be printed before 1913. That was the year that the filthy Khazarian mob created their Federal Reserve System. There are a few exceptions, as I said, the book regarding elementary law. Sorry. So elementary law, this was in 1939. But this was like one of the last times that they'd printed a book before they'd really altered everything. Because it takes years to create a book this extensive. So, and then, so in the process of what they were doing in 1933 and everything else, this book was already pretty much completely put together. So, as I said, for the most part, it's every book that you want to get on the common laws before 1913, but there are a few exceptions. Okay. Now, let's open up the law handout. It's just titled 1 Law, and in the folder you'll go to handouts, and then it'll be the first one, the first document. We're going to go over this at the same time that we're kind of looking at the map, or as best we can, and then I'll flip back and forth between this and the outline here. So the living and dead law, there's 2 different aspects, and these 2 things are the only 2 things that I do not have on this map as far as the difference between splitting them up, because I just didn't want to confuse it any more than it was already confusing. But anyway, so the spoken law, law unwritten, or lex non scripta. All the laws which do not come under the definition of written law. It is composed principally of the law of nature, here, natural law of nations, common law, and customs. So natural law, which is of course things like obviously gravity and the other things about natural law. Well, actually, let's just go through this. So we've got these various different things are unwritten law, or sorry, spoken, unwritten, and then you have lex scripta. And this consists of the constitutions of the United States of America, well, all constitutions of several states, the acts of the different legislatures, the acts of Congress, and of the legislature of several states, and of treaties. So see statute, right? So that's everything in here, statutory law. Also law of nations. And you see how law of nations does cross over common law a bit here? And the reason that is because the law of nations there's an aspect of the law of nations that does have to deal with being spoken law, meaning I'm not going to come over there and harm you. You guys aren't going to come over here and harm us. We've had trade for thousands of years and all of us are fine, right? These things existed in the aspects of laws of nations prior to there being a written statutory law or even Roman civil law coming along. I mean, the law of nations existed prior to Roman civil law. Roman civil law isn't the be-all and end-all of the beginning of law. It's not in the least bit. In fact, it goes farther back. And if you want the totality of the history of law, then I suggest watching the law history class that I did a few months back, which you can find on YouTube, you can find on Library TV, the links of which are in the Gilded server. So everything else over here is written. So basically, natural law, the common law, and the customs, which has a little bit to do with equity also as well, because equity is basically what's fair and just. So if two people, say, would have come before a judge, or say a group of judges in, say, pre-medieval times, right? We're talking like the tribes of Europe now, like the Gauls, the Visigoths, the Teutons, the Druids. They held court, yes, but it wasn't a written thing. But equity would still be an aspect of what was fair and just. And they'd come before a council and they'd say, hey, this happened or that happened, and the council would determine what would be fair and just. That's a basic aspect of equity. And so so you have spoken, and this is, by the way, this is the living form. So there's a real important reason for this. Now, again, this gets slightly into process, a little bit more into process, which we'll cover a lot more in April. But from an aspect of if you're in court, any court, doesn't matter. If you write something down in court and say you file a motion, and then the judge will, and they have tricks for this, the judge will say things like, well, is there anything you'd like to add? And if you start yapping, you've just basically negated your written documents. So when you go and you have this beautifully written motion, all you need to do when you walk in there is say, no, Your Honor, I have nothing to add. I stand on my paperwork. That's all you have to say. Now, if you want to wing it and don't want to bother to write motions, or if you're in a situation where you haven't had any chance to write a motion, say you're potted in jail or something, then of course your spoken word is just as good, and you can come upon verbal motions and dismiss things just simply by your own voice. Say, Your Honor, I'll be happy to give you my name upon proof of claim that you've established jurisdiction over the matter pending. Something like that, right? And then he'd actually have to then go and state on the record how he does have jurisdiction over one of the people. So that's spoken and written. One other thing about written and about dead form. The ancient people that I was just speaking of, the ancient tribes of Europe, many of them saw the writing of law to be an abomination before the gods, whatever gods they believed in. The reason mainly being for this was that they believed that it gave someone the opportunity and the ability to lie more easily. And this is a little interesting side note as far as etymology and the history of law is concerned. People might not know the etymology of the word testimony. Testimony is an aspect of teste, to put a teste onto something. And teste is the root of testicle, because what men back in those days, only men were able to give testimony, because what they were doing was they were actually holding on to their testicles, and if they were caught in a lie, that was what they lost if they were lying, which is why all three of those words have an etymological continuity to them. Now, sounds a bit drastic, doesn't it? Well, goddammit, it should be drastic, because these filthy attorneys lie every single chance they get. There is no truth in any of these filthy inferior courts at all. You'll never find it, because the penalties of which righteous civilizations once had are gone. Same to the aspect of just common law in general. A little interesting thing about common law in general is that first-time offense for thievery under common law is death. You hang a thief. Now, what is thievery? Theft is anything, any property that you take from somebody else. So every single crime, pretty much, under common law, when you think about it, is a form of theft. And, yes, pretty much all of them come with the penalty of death. Rape, it's the taking of a body that doesn't belong to you. And by the way, where I got all this was from this particular aspect of theft and harm I got from Mark Passio. So rape is a form of theft. You're taking a body that does not belong to you. Murder is a form of theft. You're taking a life that doesn't belong to you. Actual theft is taking the property that doesn't belong to you. And then a trespass, which of course doesn't have necessarily the penalty of death, but of course you can shoot somebody, because we do have things called castle doctrine. A trespass is the taking of someone's abode or their area without their permission. So when you get right down to it, every single aspect of crime, tort, under common law is a form of theft. And so obviously, again, why would the bankers, all that they do, bankers and attorneys, all they do is lie and steal, why would they ever want to have the people's ability to continue their common law courts of record? Because they'd be killed, right? They'd be wiped out. All of this mess would all be wiped out over here. So that's my little rant on that. Okay, into the two main divisions of law now. Natural law and positive law. That's why these circles are blue and red. I tried to make them pretty much equal and pretty much next to each other so you can kind of get the aspect. And notice they are not touching. So what I'd like to do now is switch over and read from the law handout. And I'll kind of do a restart here, and then we'll scroll down to natural law and positive law. So again, this is from Bouvier's Law Dictionary. So law, in its most general and comprehensive sense, law signifies a rule of action, and this term is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. And that, again, comes from Blackstone's commentaries, which you can go read on your own because you guys now have a copy of it. In its more confined sense, law denotes the rule, not of actions in general, but of human action or conduct. And then it says in the civil code of Louisiana, because guess what? Louisiana is a civil code state, which is the reason why you get your passports out of the Port Authority of New Orleans. Anyway, it is defined to be a solemn expression of the legislative will. Well, only in countries and nations that are run by code. Common law countries, no, that is not the case whatsoever. Common law countries, the decree of the sovereign makes law. And so it's the decree of whatever we decree to be the law. You walk into a fellow American's house, you are under his sovereign law, period. You're also under his sovereign protection as well. But if you violate his law, he has every right to prosecute you in whatever way he sees fit before a court of record and say, hey, yeah, I welcome this guy into my house, but he did this, that, and this. And because he did this, that, and this is the penalty. This is my law, which I'm decreeing. And these are the penalties of being under my house, under my roof, which create this law. And it doesn't just have to do with bits of wood and shingles under a roof. It has to do with the formation of the house. So anyway, we'll cover that a little bit later. So here, this is the main part of this definition of law. So this is part one of law. So this is the second definition of law. This is where we're going to get into this whole spiderweb of stupidity over here. Law is generally divided into four principal classes, namely natural law, the law of nations, public law, which is, I didn't put public law in here, but it's basically an aspect of common law and equity. So public law would kind of be basically here. But the trouble is that public law can also be written into statutes. And so it was kind of impossible to be able to create them, because it would almost have to be like a connection between here and around to just here. But anyway, but just think of public law as a harm. That's the best way to think of public law. And private or civil law, right? So that's Roman civil law. When considered in relation to its origin, meaning the two ways that law is created, it is statute or common. That's it. There's two different origins of law, common and statute. Those are the only two, okay? Those are the origins of law as far as man-made law is concerned, right? Natural law is obviously an origin of God, but this is specifically talking about written, the aspects of what we have as law as far as man is concerned. You got common law and statute. That's it. When examined as to different systems, it is divided into civil law, common law, and canon law. And these Roman civil law and canon overlap a little bit here from the standpoint of basically the cult of Rome. This gets where this intersection here between civil law and canon law or ecclesiastical is concerned. You're talking about ancient Rome in here. Priests of El, that the emperor had to go to the priest before he went to war to ask, to agree for the money and yada yada yada. That's where this gets into. But now ecclesiastical law, as far as it's concerned, the Vatican being its own city-state, this has basically been separated now and pulled over here away from it over a period of time. But at one time it was connected, which is why I made point to go ahead and cross it there. Okay, so that's different systems. When applied to objects, it is civil, criminal, or penal. I didn't put the criminal or penal in there. This is an aspect, again, of statutory law and the different ways of which you're just applying law to objects, okay? It is also divided into natural law and positive law. That's the major two separation here that I wanted to make point around this whole map, is the difference between natural law and positive law. And into written and non-written, which we just spoke of. Into law merchant. So you got the law merchant here. Martial law, which is basically military law and laws of nations. So I could have put martial law here, because it's basically an aspect of courts martial. So it would be overlapped with Maritime Admiralty, military, and law of nations. So this is martial law here. And you could have a certain aspect of martial law being slightly into statute, but it would be kind of like saying, if martial law is in full force and effect, then these things are basically negated. That'd be the only part of this that would state anything regarding a martial law. But martial law would basically be here, okay? Municipal law, which is just Roman civil law in a different name, and foreign law, which is an aspect of the law of nations, but foreign to whoever you are. And then when considered to their duration, and this I did not put in here either, because this is an aspect of time, and of course there's only 2 dimensions on this, and I can't put a third dimension in there. So they're either immutable, arbitrary, or positive. Now, from an aspect of positive, yes, this is positive law, so I guess it's an aspect of that, but immutable would kind of be the aspects of natural law. So I guess in a way I kind of have it in here, but I didn't specifically label it as such. But I suppose, under natural law, I could put immutable here. So I guess I don't need 3 dimensions. And as to their effect, they are prospective and retrospective. So I didn't put that in there either. But so the major divisions are all explained and shown here. So let's go back to the outline real quick. So I'll go down to, so let's do the main 2 separations now. Let's go through natural law, and let's go through positive law by going through the definitions in Bouvier's. So let's scroll down to law of nature. The law of nature is that which God, the sovereign of the universe, has prescribed to all men, not by any formal promulgation, but by the internal dictate of reason alone. Right? Aspect of natural law is based on reason. Is that the right or the wrong thing to do? You know what the right or wrong thing to do is all the time. It's using your reason. Okay, so that's natural law. It is discovered by a just consideration, right? Just consideration of the agreeableness or disagreeableness of human actions to the nature of man. And it comprehends all the duties which we owe either to the Supreme Being, to ourselves, or to our neighbors as reverence to God. Self-defense, temperance, honor to parents, benevolence to all, a strict adherence to our engagements, gratitude, and the like. So one of the quadrants of the Vocational Science of Freedom is self-defense. And I would actually put that the rest of the other three are also an aspect of laws of nature. And they are self-reliance, self-awareness, and self-governance are also all four quadrants of the Vocational Science of Freedom are aspects of the law of nature. Okay. So the primitive laws of nature may be reduced to 6, namely comparative sanguinity or reason, self-love, meaning you take care of yourself. That doesn't mean being ridiculously narcissistic. The attraction of the sexes to each other, meaning we're attracted to each other and we procreate and we make babies and we continue our species. The tenderness of parents towards their children, meaning also this is an aspect of the right of parents to protect their children against anything that would come upon them, to the death, literally. Their religious sentiment, which is whatever you wish it to be, which is of course why we have the First Amendment, freedom of religion, and sociability. We have the right to socialize with whoever we want to, and the right not to socialize with whoever we want to. You don't have to be around anybody you don't want to be around. Okay, number 3, when man is properly organized, he is able to discover moral good from moral evil. And the study of man proves that man is not only intelligent, but a free being, and he is therefore responsible for his actions. Okay, the aspect of being responsible for your actions, that means you've come of full age, right? Under the common law, if you've come of full age and you're right here, if you've come of full age, have been found to be living, that you put yourself right here, well, maybe right here a little bit from the standpoint of you want to be equitable to other people around you. But as long as if that's it, and you don't have any contracts with anybody else, you're here. You're here and you're free. Done deal. Okay. Where it gets into a problem is where you don't have responsibility for your actions, or you tell somebody else to take responsibility for them. Meaning you've entered into contract, say, with the Social Security card, or you begged Daddy, Caesar, to have a license to go do something that was in itself lawful to begin with. Well, then you're not taking responsibility for your actions, are you? You're asking somebody else to do it for you. You're saying, I don't know how to take care of my own actions. I don't know how to govern myself properly. Please, Daddy, tell me what I should do. And he'll say, sure, little infant, you get to be under statutory law. You get to be under Roman civil law, statutory law, and all the rest of this garbage if you enter into that sense of being, right? That you're not responsible for your own actions, that you don't know good from evil, that you're not sovereign, that you have no reverence for temperance or self-defense or your own parents, right? Or your neighbors. All that would say, okay, you don't know what you're doing. Now down here, there's ways to deal with that in the community, of the community. Over here, this is the attorney and the oligarchs and the Luciferian bloodlines telling you what you will do because you're too stupid to figure it out for yourself down here with other people, right? And then the judgment we form of our good actions produces happiness. On the contrary, the judgment we form out of our bad actions produces unhappiness. Right and wrong, people. It's a very aspect of the law of nature. Now, I'm going to bring something up really quick, which I want to share with everybody regarding a post that I did on Gab. I keep it up on my profile on top here, so everybody can read it. So, a right is anything that you can do that does not cause damage, harm, loss, or injury to other people or their property. These natural law rights predate any constitution, state, or federal, and therefore exists before any government exists, and therefore cannot be given by any government. Any attempt to deny the rights of another is an evil. That is the definition of a right and the definition of an evil. Defend the former and eliminate the latter always, and you will have a just and prosperous society. And George Lincoln Rockwell put it, it is not the evil itself which is horrifying about our times. It is the way we not only tolerate evil, but have made a cult of positively worshiping weakness, depravity, rottenness, and evil itself. That is the problem of where we find ourselves. Because all of this garbage over here is all run by the Luciferian scumbags, by the law attorneys. A turn. A turn means to take one and to give to another. Okay, that's what an attorney means, to take from you. And they'll keep taking 30% until you wake up, until you destroy everything that's over here and put it back into its hole, which should only have to deal basically with corporations. Chartered corporations, which have a limited charter that are only supposed to do things for the benefit of the people over here, as long as they don't cause damage, harm, loss, or injury. And the second that they do, you pull their charter, and that's it. So we're no longer ruled by idiot corporations or oligarchs or the Luciferian bloodline fools, which stem all the way back to Babylon and before. You get rid of all that. The whole idea of divine right of kings, it has nothing to do with the laws of nature, natural law. Okay, to continue, number 4. Every animated being is impelled by nature to his own preservation, to defend his life and body from injuries, to shun what may be hurtful, and to provide all things requisite to his existence, right? To provide all things requisite to his existence. That's the right of self-reliance. You have the right to go out and pick berries to eat them. You have the right to go fishing. That is your right. You are the highest being, living being on this planet. You have the right to do that. You don't need a license for it. You should be doing it in, obviously, your own republic, right? But that constitutes the vast majority of North America when it comes to being an American. So, got plenty of places to do all these things, right? Now, if it's on someone's private property, which is the difference between we have common law and natural law. So in here, we do have private property. So that would be here. So you'd have to ask your neighbor if you wanted to, if you could fish in his pond, that's fine. But you don't have to ask your neighbor if you want to go fishing in the river, because the river belongs to both you guys. It belongs to everyone. It's common lands, right? Common lands or common waterways. That's for everybody. Great. So what you should be able to go fishing there. What this garbage should not be able to do is to destroy what is common to all for profit, to privatize what is common to all and control it. That's the evil of what exists over here, this garbage. That's the main difference. You see how these two are separated, and that's a huge part of it, is the absolute existence of the planet. I'm looking outside right now and looking up in the air, and I'm seeing funny little white stripes in the sky. You think that's a destruction of this, or destruction of this because of this? Absolutely. Why? Because we're being sprayed like we're bugs. So that's a destruction and something that is hurtful of an aspect of, and is in opposition to what is being a free being. If all this mess over here keeps destroying without my consent what I should have under natural law, then this is what needs to be destroyed. All of it needs to be destroyed, ended immediately. And we're the only ones that have the power to do that, because this is all fiction. This is reality. Okay? So number 5. Or wait, did I finish 4? Oh, no, I didn't finish 4. Okay. So hence the duty to watch over his own preservation. Suicide and dueling are therefore contrary to this law, and a man cannot mutilate himself nor renounce his liberty. Interesting. Nor renounce his liberty. What that literally means is that you can't turn yourself into a slave, and slavery is unlawful. Well, keep entering into contracts over here. Basically what you have done, unknowing to you, is renounce your liberty. But we'll get into how to get rid of that later. Okay, number 5. The attraction of the sexes has been provided for the preservation of human race, right? As I said before. And this law condemns celibacy. The end of the marriage proves that polygamy and polyandry are contrary to the law of nature. Hence, it follows that the husband and wife have a mutual and exclusive right over each other. That's right. The beginning of that connection of natural law, right? So the wife to the husband is the property. The husband to the wife is the property through natural law. Why? Because you found something in nature which you wish to make your property. No one else had claimed it, so the two of you claim yourselves to each other. That's called a union, right? So why in the hell is the corporate state coming into your union, your natural law union here? It's because you signed a contract under this filthy garbage, the law merchant, that says, oh, well, you can come over here and have part of our production. What's the production of the union of man and woman? It's called children. And in this filthy side of things, they actually call them issues. Children are called issues over here, in case you didn't know that. Here they're called children. Over here they're called issues. Wonder why. Right? But point is, no license, no agreement. No issue, got no issue. Get away from me. Put a huge line right through here with that aspect, right? And I know plenty of people that are common law married. And that's the proper way to be married. If you have a license, then they're going to come looking for their issues, right? What they think they have a part of. So anyway, number 6. Man from his birth is wholly unable to provide for the least of his necessities, but the love of his parents supplies for this weakness. This is one of the most powerful laws of nature. The principal duties it imposes on the parents are to bestow on the child all the care its weakness requires, to provide for its necessity of food and clothing, to instruct it, to provide for its wants, and to use coercive means for its good when requisite. Meaning, no, I'm going to paddle your butt if you try to climb up that tree again, because you can fall out of it and you're only 4 years old, so don't do that. Or whatever the case may be, right? Look both ways before crossing the street, all that good stuff. So number 7, the religious sentiment which leads us naturally towards the Supreme Being is one of the attributes which belongs to humanity alone, and its importance gives it rank to a moral law of nature. From this sentiment arises all the sects of different forms of worship among men, and where you have the First Amendment and all the other amendments of the states, which guarantee your right to believe whatever you want. Because without freedom, you don't have the right to be a Christian, or in my case, a Taoist, or a Buddhist, or anything. Without freedom, you have nothing. So, number 8. The need in which man feels to live in society is one of the primitive laws of nature. Trust me, an interesting thing that happens when you're completely alone for about 5 months. I was alone completely for about 9 months. Tiny bit of interaction here or there, but pretty much completely alone. Interesting things start to happen. Not only do you see things differently, but you start to realize that purpose is an aspect of function between other fellow beings to be grateful or interested in or happy with something that you've done, right? So what I'm getting at is that the connection of people is a requirement of man itself. As the saying goes, no man is an island. So on this law are based the assistance, course. I don't know if that's a misprint. I've never seen that word before. And good offices which men owe to each other, they being unable to provide each everything for himself. Again, no man is an island, right? Okay. So that's an aspect of natural law, your laws of nature, right? So now let's get on to positive law. Positive law, as used in opposition to natural law, right, which is why they don't touch, may be considered in a threefold point of view. 1, the universal voluntary law, or those rules which are presumed to be law by the uniform practice of nations in general, and by the manifest utility of the rules themselves. So again, you get this aspect of nations in general, right? That we're not going to go to war with you. You're not going to go to war with us. This is common. We're understanding this. So this is why common law and laws of nations kind of cross over here a little bit, because we have a common understanding between the two of us, and that we're saying, yep, this is universal voluntary law. We're voluntarily saying, nope, we're not going to go to war with you. You're not going to go to war with us. We're cool, right? And the utility of the rules themselves, meaning we'll also trade with each other. Hey, you guys, we don't have iron ore over here, but what we do have is we have some really good fields that produce a lot of rice. So can we trade our rice for your iron ore? They say, yeah, sure, no problem, right? So trade in of itself of people is an aspect of this positive law, but it's also an aspect of common law too. Okay. So 2, the customary law, or that which from motives of convenience has, by tacit but implied agreement, prevailed, not generally indeed among all nations, nor with so permanent a utility as to become a portion of the universal voluntary law, but enough to have acquired a prescriptive obligation among certain states so situated as to be mutually benefited from it. Now, what does that long-winded bunch of difficult thing to read mean? Okay. Basically, all that means is that, guess what? Sometimes there's a bunch of nations and they're all common law nations and they all work together because they were all at one time a part of the same empire, but then, there is no more empire. So we all do stuff by common law because it just works well. That's all that means. All that gibberish. That's all that meant. 3, the conventional law, or that which is agreed upon between particular states by express treaty, meaning now we've got treaties between laws of nations saying, I'm going to write this down under Roman civil law and statutory law, or UCC and law merchant from a standpoint of our trade agreements, right? Or Maritime Admiralty law saying we're not going to torpedo your boats, right? Or military law saying that we're not going to shoot you. So law binding on the parties among whom such treaties are enforced, right? So this is where you ask, treaties are a written aspect of this. So this is where you get the laws of nations and aspects of treaty, okay? So this is your basic, this is how the basis aspect of where I started this whole chart. This whole chart is centered around the separation of natural law and positive law. That was basically how I set this chart out. Those were the first 2 circles I started with, because I wanted to start with 2 things that could be juxtaposed to each other in a way where I could connect everything else. So that was the most logical way to put those 2 together. Okay. So that's law positive. So now let's go back and outline. Sorry. So that's natural law and positive law. So we covered those. And another thing aspect, yeah, the customary law is also an aspect of the law merchant and equity, right? So the law merchant and equity of customs. The law merchant is the common law of merchants, which is why the law merchant and the common law kind of intersect here a little bit. They touch. And law merchant also has a little bit to do with equity. It's supposed to be the fairness between merchants is what it's supposed to be. And it was laid down a long time ago, and I'll get into the specific of the law merchant and how it connects to Maritime Admiralty a bit later today. But the aspect of the law merchant is an aspect of the common law of the law merchant. So it has an idea of law merchant, but it's common law, but it really deals more with the sea and banking and merchant affairs. Okay, compared to our common law, which deals with rights and wrongs and what we do on the land, and our custom and usage, which things on the land. So now let's get into the 4 different classes of law, which are, again, natural law is another class. So what is natural law? We just read, and I already explained that every crime is a form of theft, right? So we remembered that. Common law is natural law put into practice in a society for the protection of everyone's rights. Now that's just my over 25 years of studying law and looking at what common law is. That's pretty much my overview of what common law is, right? I'll read specific definitions of common law, but that's pretty much how I like to sum it up. It's basically natural law put into practice in a society for the protection of everyone's rights. So the idea of due process, right? That both the rights of the plaintiff and the defendant are protected. That's an aspect of common law that you shouldn't steal from your neighbor. So, law of nations, this deals with treaties, UCC, which is Uniform Commercial Code, which I get into detail, much more detail, in the history of law class. And so I cover the whole UCC of where it came from and how it morphed. It's basically a morphing of Roman civil law. So you have the law of nations. And of course, like I said, the law of nations existed pre-Rome. It's not like Rome came up with the idea of treaties and nations, for goodness sake. And so nations had trade long before Roman civil law came along. Well, how did they do that trade? Well, a vast majority of it was done over the sea, right? In the back and forth across the Mediterranean. And that was Maritime Admiralty law. And the trade that was done on land and on the sea, dealing with bank notes, if you will, things like warehouse receipts, a receipt in general. I write out a receipt for you, right? A bill of sale showing that you gave me a certain amount of lawful consideration for a certain amount of barrels of stuff off of my boat, right? The aspect of loaning money and debt notes and things of that ilk all have to do with the aspect of the law merchant, right? So the law merchant does have some to do with not just being on land, but also has a bit to do with sea. And the law merchant is also the continuation of what now morphed into the Uniform Commercial Code, the UCC, which is now a global thing, which, yes, it kind of did stem out from Roman civil law. Okay, so that's the law of nations, where you've got all of these things connected in under the law of nations, previous to Rome. Then public law, which again, like I said, I didn't put in here because public law would almost have to, it would basically be here, but it would almost kind of have to stretch in some sense to being under statute, because public law is a harm, but public law can be, I'm just going to put it in quotes here, or in brackets, can be written, right? So into statutes. So, and you'll see this in federal law and state law, that there is public law that is written into statutes. And public law is law that applies to everyone because it is a harm. Now, is that also not an aspect of natural law? Yes, it is. Because obviously, do no crime. If you do a harm, damage, harm, loss, or injury, it's a theft, right? So that's an aspect of a harm as well. But it doesn't have to be. So it can be written or unwritten is basically what I'm getting at. Public law can be written or unwritten. It is an aspect and can be an aspect of common law, but it can also be an aspect of statutory law and even maritime admiralty law, meaning don't ram your boat into somebody else's boat. And if you're on course, then you can stay your course, and somebody else should, alter their course. If you guys are on the same heading, that's all from an aspect of ships at sea. So don't do any harm. So common law can also be considered as a part of the public law of the land that are the customs of the people who live there. That's another aspect of seeing how public law works, right? And then the last class of law is private Roman civil law. Contracts, trusts, pledges, consent is needed. Municipal law is also part of that. Statutes, acts, ordinances of municipalities, and corporate law. All of that is private Roman civil law, which, as we see, encompasses all the rest of this spiderweb of garbage. And I think, let me look up, and let's go back to the law. And I believe, let's look up and read the totality of what civil says. So let's do the aspects of civil versus common, right? Because we got Roman civil law and we got common law over here. Notice they do not touch. Okay, there is not a touching between Roman civil law and common law. They are separate. So this term civil law is, and again, this is out of Bouvier's, the term civil law is generally applied by way of eminence to the civil or municipal law of the Roman Empire, without distinction as to the time when the principles of such law were established or modified. In another sense, the civil law is that collection of laws comprised of the institutes, the codes, digest of the Emperor Justinian, and the novel constitutions of himself and some of his successors. 2. The institutes, now this is again the Roman institutes. The institutes contain the elements of the first principles of the Roman law in 4 books. These digests or pandects are in 50 books and contain the opinions and writings of eminent lawyers digested in a systematical method, whose work comprised more than 2,000 volumes. The New Code, or collection of imperial constitutions, in 12 books, which was a substitute for the Code of Theodotus. The novels, or new constitutions, posterior in time to the other books, and announcing to a supplement to the code, containing new degrees of successive emperors, and new questions happened to rise. These from the body of the Roman law, the Corpus Juris Civilis, as published about the time of Justinian. And so right there was a little aspect of the difference of history. And after I get done with reading this section of Roman civil law, I'll get into a better historical, because this of course comes from a law dictionary. I have a better historical record, which we'll get into after this, regarding Roman civil law and common law from a treatise, of which it's a little bit better written. So they speak in here about the 12 tables, and they speak in here about what the Corpus Juris Civilis, which is what Justinian did, but they don't really give much of a description as to the reasons why, but I'll get into the reasons why later. Okay, although successful in the West, these laws were not, even in the lifetime of the emperor, universally received. And after the Lombard invasion, they became so totally neglected that both the codes and pandects were lost until the 12th century AD, 1130, when it is said that the pandects were accidentally discovered at Amphi and the code at Ravenna. But as if fortune would make an atonement for her former severity, they have since been the study of the wisest men and revered as law by the politest nations. Well, isn't that nice? I would disagree with that last little statement. I would, if I were me, technically just remove that, but I'll leave it there. By the term civil law is also understood the particular law of each people, opposed to natural law or the law of nations, which are common to all. So, in a sense, I guess I probably shouldn't have put the law of nations over Roman civil law, I guess, from this standpoint. So, but again, the law of nations being developed quite a bit out of and from Roman civil law, I still see that as a reason why it's kind of connected, or they should be connected. But so we can take this definition yay or nay from that standpoint. Number 5, civil law is also sometimes understood as that which has emanated from the secular power opposed to the ecclesiastical or military. Now, that's why the military doesn't touch Roman civil law. Now, the reason I put the ecclesiastical law a little bit touching the Roman civil law is, as I stated before, because of the Roman cult, when you go back that far. Number 7, Judge Swift in his System of Laws of Connecticut prefers the term civil law to that of municipal law. But like I said, they're kind of connected, or they're basically the same thing. He considers the term municipal to be too limited in its significance, and he defies civil law to be a rule of human action adopted by mankind in a state of society, or prescribed by the supreme power of the government, requiring a course of conduct not repugnant to morality or religion, productive to the greatest political happiness, and prohibiting actions contrary thereto, and which is enforced by the sanctions of pains and penalties. So yeah, in Roman civil law, you always have pains and penalties for do as I tell you to, right? And of course, where does all that money go to? It goes to Caesar. Render unto Caesar that which is Caesar's. So, in other words, don't get in contract with the bastard. So that's Roman civil law, right? And there's just some other interesting information here that this is where you can go find more information about Roman civil law. Okay, now on to common law. Or wait, well, you know what? I'll read common law and then I'll go to the treatise. Let's do that, because that'll probably take us into the first break. So common law. The common law is that which derives its force and authority from the universal consent and immemorial practice of what? the people. It has never received the sanction of the legislature by an express act, which is the criterion by which it is distinguished from the statute law, right? Common law, statute law, no touchy. These two things have nothing to do with each other. Now, when it does say here, it says it's never received the sanction of the legislature by an express act. Well, there have been ones since this was written in 1859 that it does state that. And I've covered that before in some of the free classes where we, particularly the class that we did not all that long ago regarding traffic and the right to travel. I believe I covered and gave examples of Illinois statutes, at least, that specifically state that the common law is still in full force and effect. Now, does that mean that it's received sanction from the legislature? Yeah, I suppose you could have a debate about that, but they certainly acknowledge it because they have to. I mean, this is the republics. Each and every state is a republic, and the republics, we're all in a common law jurisdiction, for the exception of Louisiana. Make a point about that. Louisiana is not a common law state. It's a code state. It's always been like that. And it stayed that way because Jefferson bought it from Napoleon with it being that way. It's never changed. So under the Louisiana Purchase, we got it like that, and it stayed that way. But obviously the rest of the territory of Louisiana Purchase was all divided up and made sure that it had its common law under the Northwest Ordinance, which is one of the foundational documents that I do have in the handout section. So we have foundational starting books, and just to make a note here in the handout section, the second folder is the foundational documents. The foundational documents include Declaration of Independence, Articles of Confederation, Northwest Ordinance, the Constitution of the United States of America, the organic acts of all the territories prior to statehood. This was a very interesting document that I was stunned even existed. So they put all of the organic acts, all of the territorial acts are in this one PDF before they became states. And I tell you what, there is a lot of stuff hidden in there. There is a tremendous amount of common law information hidden in the territorial acts of each state before it became a state. So I highly suggest everybody get around to reading this at some point in time. And the New Jersey plan, which was their aspect of what they were going to do for their Constitution, and the Virginia Declaration of Rights, which I've always found to be one of the most powerful state right declarations that exist in any of the colonies, and that's probably because Jefferson wrote it. So anyway, that's just the foundational documents. We'll get into some of that later, but I just wanted to make a note of that the foundational documents are in there. And so anyway, back to common law. So it has never been reduced to writing by this expression. However, it is not meant, meaning the common law, right, has never been reduced to writing. That's why it's unwritten, or most of it's unwritten. By this expression, however, it is not meant that all laws that are at present merely oral or communicated from former ages to the present solely by word of mouth, but that the evidence of our common law is contained in our books of reports. Now, what's a book of reports? Okay, a book of reports is basically case law, but from courts of record. Okay, so it's where the juries have determined, now this is what our law is here. This is right. This is what we're going to do. And from that, then judges can read from that and go, okay, well, this is how the people have ruled before, and this is how other judges have ruled before based on what the people said, and this is how I should rule now because this is the common law. That's what they're talking about regarding in our books of reports, and depends on the general practice and judicial adjudications from our courts. Again, the same aspect of having case law. So case law, when people say, oh, it's judge-made law, not really. I mean, it could be from a standpoint if it was a chancery court, but we'll get into the different kinds of courts later as far as what those are. But for now, meaning so that the court of record proceeding according to the course of the common law. That's what they're talking about when it comes to our courts, right? So number 2, the common law is derived from 2 sources, the common law of England and the practice and decisions of our own courts. Again, courts of record. In some states, the English common law has been adopted by statute. Again, Illinois, which is where I showed that there was the way that the Illinois statute was written, said that all the various English common law between such and such king and such a king is still in full force and effect until repealed by the legislature. I'm paraphrasing, but that's basically what it said. And from that, then you have a sense that the common law is all of the English common law from those periods. You can still use in Illinois, meaning you could take a case from England and say, hey, guess what? This case is good common law, and I'm standing upon it, and this is how you should rule. Da da da. And they'd have to take it into consideration, and if they didn't, then you'd have a reason to file a writ of error to the appellate court or the Supreme Court and say they erred, they went out of their box. I don't know what he's doing. So, but that's more process, which we'll get into the April class. So in some states, the English common law has been adopted by statute. There is no general rule to ascertain what part of the English common law is valid and binding. To run the line of distinction is a subject of embarrassment to courts, and the want of it a great perplexity to the student. Yeah, well, there's the reason why. It's all a absolute cluster destruction over here, and it's because the attorneys keep doing what they're doing. And I'll get into the fight between common law and Roman civil law, and I'll get into the fight between common law and Maritime Admiralty later on today. But there's a reason. There's a reason. It's because all these various different jurisdictions and things that fight for position and power, influence, it's to rule over all of mankind, except down here. But so it may, however, be observed generally that it is binding where it has not been superseded by the Constitution for the United States of America, or of the several states, or by their legislative enactments, or varied by custom. So what does that mean? It means the common law is in full force and effect of every single way that it was in England, unless it has been altered by these certain things. Okay, wonderful. Which means the Magna Carta, by the way. The Magna Carta, which was written in 1215 AD, okay, you can still stand on, because it has not been altered by any of these things. In fact, many of these things, like the Constitution of the United States of America and of the several states, has aspects of the Magna Carta in it. So, yeah, so law continues until it has been altered or changed by custom or by legislative enactments of whatever governments to alter it. It's still there, which is why they're doing what they're doing right now to us in their system of pledging and administering our estates forever as infants. The reason is because the foundation of how these laws were set up and these various different things existed long before there was an America. Okay, so that's why you have to pay attention to all of them. So anyway, back to this. So number 3, the phrase common law occurs in the 7th article of the amendments of the Constitution of the United States, right? In suits at common law, where the value in controversy shall exceed $20, and that means 20 actual dollars. That means $20 as in a dollar of 1 ounce silver dollar as per the Coinage Act, okay? Meaning real money, like real money, not worthless Federal Reserve notes. Right? That's 20 real dollars, which is why I actually ask for lawful consideration for these courses and for anybody else's, for my time, if anybody else wants private courses. So, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States. So, what does that mean? It means when you have a court here and a superior court, right, I'm going to pull this back a little bit because I want to make this note here. So when you have a court, a superior court, do have a case going, they have a trial, and a suit at common law, right, in a court of record, because that's what a court of record is. It's a court that proceeds according to the course of the common law, which again I'll get into that in a minute too. And the value shall exceed $20. So no fact tried by this jury can be otherwise re-examined in any of these filthy courts, period. There was a damn good reason why the founding fathers put that in there. Is that they knew about all this garbage, but they also knew that this was above it. So they said, nope, anything that gets tried over here cannot be re-examined in any of this stupidity over here. Because what are the courts of the United States? They're federal courts, right? They're not courts of record. They're not common law courts. In fact, well, I was going to get into the Erie Railroad decision, but I'll leave that for later. Some people have said the Erie Railroad decision got rid of federal common law. Well, I'd argue that there was never any federal common law, really. Federal from an aspect of what? That I suppose if a state officer exceeded his jurisdiction in some way, shape, or form as to the federal Constitution, say with like the Second Amendment, you would have a right to sue the state agent in federal court because it would be a matter of the federal Constitution, and that would, from a common law standpoint, be a right at common law, which you had prior to the federal Constitution and the Second Amendment being written. Yeah, that would be a common law federal issue, I guess. But ultimately, there would be no reason why you'd have to take him to federal court because the states all have the same rule. All the states have the same somewhere in the same aspect that you have the right to bear arms. All of them, in case nobody knew that. So you can stand on your state constitution, which is above the federal constitutions anyway, and just sue them in state court. So anyway, that's my little rant on federal common law. And we'll get a little bit into more of this later when we get into some more of the treatises. So that shall not be re-examined by any court of the United States than according to the rules of what? The common law. So, yeah, you could retry it, but only by the rules of the common law. Now, what does that mean? Well, you could have a superior court of record, a jury of 12, say, okay, we find this. But something might come along later, or somebody might say, well, you guys didn't quite do a very good job there. And what could happen? Well, you could bring in 25. You could bring in a full grand jury of 25, and you could sue out a writ called a writ of attaint, meaning that the accused has been attainted. And you could sue out a writ of attaint, and you could give it directly to the grand jury, the 25. And what would happen then is that the entire case would be tried in front of the full grand jury. That would still be common law, and that would be one of the few times where this situation would happen, right? Then according to the rules of the common law, well, a writ of attaint to a full grand jury would still be under the rules of the common law. Now, not as though anybody but me is ever going to teach you that, because I can guarantee you that the attorneys don't even know it exists. But it's one of these common law writs that you can certainly use, and there's no reason why we can't use it and shouldn't be using it to get, I would say, everyone out of these filthy corporate prisons, of anyone that hasn't done a damage, harm, loss, or injury. We should do a writ of attaint on every single one of them. But that'll be a homework assignment for the next 10 years for everyone, for all of America. Because that homework assignment is probably going to take 10 years to finish. And hopefully I will still be around for it. So to continue. The term is used in common law. The term is used in contradistinction to equity, admiralty, and maritime law. Right? So when you're talking about common law from the standpoint of what is happening in the courts, that's a contradistinction to equity, admiralty, and maritime law. Now we'll see here that equity is kind of inside common law, like literally inside it. Well, there's a reason for that. Well, yes, this is a distinction and contradistinction as to America, because remember, we're reading from Bouvier's here. that the courts of equity that deal with equity matters that basically are chancery courts are separate from common law courts. But the aspect of equity itself as being a jurisdiction of law does have its roots in common law, and it came from the common law itself. So that's why it's inside, not outside it. So in case nobody gets confused with that. So number 4, the common law of England is not in all respects to be taken as that of the United States or of the several states. Its general principles are adopted only so far as they are applicable to our situation. So again, what does that mean? The common law of England is not in all respects to be taken as that of the United States. Why? Because they're not sovereign. We are. Or of the several states. Why? Again, because they have different setups as far as their governments are concerned compared to how our situation got set up, where there was first the colonies, and then we said, nope, we're states, and then we said, nope, we're going to have a confederation, and then later on, through some silly, nefarious shit, I said, Hamilton and a few other people said, let's have a federal constitution, and then we did that, and so on and so forth, right? Well, that's entirely different than the organization that they have in England. So from that standpoint, not everything's going to follow exactly, but its general principles are adopted only insofar as they are applicable to our situation. So if you want it to be applicable to your situation, as far as some aspect of the common law of England, then make it applicable. If it's not, then don't use it. It's that simple. Okay. So now after you read common law and civil law, what I'd like to do is I'd like to open up one of the treatises that we have set aside here and read from it. So an elementary treatise on the common law, which I already had open. And I'm going to scroll down to, because what I want to show everyone is the creation of where these different courts came from, and from England, of course. This is all English courts. Okay. So I'm going to show here is the creation of these different jurisdictions and where they come from. So we just got done with talking about what common law is. So I want to give an idea of how the common law was kind of chopped up, if you will, in English jurisprudence, so that you have a sense of what in the hell is going on here in American jurisprudence, because it will confuse you if you obviously confusion. It will confuse you if you don't get a sense of where these things came from and what came first, the chicken or the egg sort of scenario. So again, I'm reading from the 1906 treatise. It's in the handouts. It's under common law. So if you go to the handouts, go to common law, and open up 1906, an elementary treatise on the common law. And I'll be in the PDF, it'll be page 116. And chapter 10, the English courts. So, there were anciently in England 3 kinds of courts: the popular courts, the private courts, and the king's courts. The popular courts were assemblies of the people. Right? This is where you have an aspect. Now, prior to William the Conqueror, in coming over and messing everything up in 1066, what you had was called the Court of 100, which I'll get to here. But so you had assemblies prior to this where they were basically running their own kinds of grand juries prior to 1066. And then William the Conqueror comes over, screws everything up for a couple hundred years. The barons say, we've had enough of this shit, and take his seed line, John, corner him basically at Runnymede and say, sign the Magna Carta or we're going to cut your filthy head off. Which not only acted as courts in the popular sense, but also possessed administrative and to some extent legislative powers, right? So these assemblies, the people would say, no, we want, this is what we want to do every year, or this is how people should take care of the roads, or whatever the case may be. The Constitution of the County Court and its functions as an administrative body have already been spoken of, which I won't get into, but it's basically what I just said. This class of courts were of great antiquity, having existed among the English tribes before they settled in Britain. Right? So this gets, like I said, this gets back to Celtic Druidic. before the Saxons, before the Vikings, before all of them intermingled with each other. When they sat as courts, the whole body of the suitors were the judges, through convenience sake, a part of their business was generally transacted by a small number of selected persons, frequently 12, right, which is where we get the number jury from. Nobody knows where that came from. I just told you. From which is derived the number of the jury in modern times. So now the 100 Court. The 100 Court was an assembly similar in its composition to the county court. It was held once a month in each 100. Now, what is 100? Let's see if I can describe this. 100 is a description of basically the area of basically 100 families. It was a way of dividing up counties, not unlike the idea of a shire, and later what became the idea of a township. Okay, so 100 is just a type of division of a county. Okay, having a general jurisdiction at common law as a court of first instance, meaning you bring everything there. It fell into destitute some centuries ago. Not really. Honestly, it wasn't. It didn't fall into destitute. William the Conqueror destroyed it because people had local rule, and filthy serpent seed line pieces of shit don't like that. So anyway, I digress. Though not formally abolished until statute in 1867, so it stuck around for a while. But a session of it held under the presidency of the sheriff, originally for the view, and by the way, sheriff, shire, reeve, that's where that term comes from. A shire reeve is a sheriff. Originally from the, quote, view of frank pledge, that is, to see that every man was properly enrolled in a frank pledge or tithing, continued to exist until modern times as a petty criminal court with the sheriff for judge under the same name for the sheriff's turn. The county court, in its general capacity, heard appeals from the 100 Court and other inferior courts, excluding generally the private courts, and also to some extent exercised original jurisdiction, especially in important cases. Now, what's the difference between original jurisdiction and what would basically be an appeal jurisdiction? Okay, so your common law courts of record have original jurisdiction on basically everything, for the exception of things that are specific not to them. Now, going this far back, we don't have situations dealing with Maritime Admiralty law, but you would have had things dealing with the law merchant. And the law merchant did its own little things in what was called fair courts, like the Fair Court of St. Ides, which I believe I put as a document to take a look at as far as historical interest is concerned under the law merchant. Yep. So the thesis on the law merchant and the fair court, there is a thesis about the law merchant where it specifically talks about that they had their own types of courts during this time period. So that would be separate from, right? So they would have original jurisdiction in dealing with matters of law merchant affairs, right? So I'm not going to read all the rest of this aspect, but I just wanted to show you the difference between like where the common law courts came from. So they predate England itself. Okay. So yeah, you get an aspect of common law of England, but I mean, it really isn't even English. It predates all of it. So, and it predates Rome too, by the way. Common law exists before Roman civil law exists. So I'll skip this down. I'm going to skip down to, because these are some of the other special courts, I'm going to skip down to Chancery here. Well, I guess I'll cover this real quick. Just the common pleas of the King's Court. So I'll get into the King's Court. So the prosecution from common pleas in the King's Court was not at first matter of right, but of grace. So the king didn't have to take a case if he didn't want to. The king was not bound to trouble himself about private disputes unless he chose to. He took advantage of this to exact money from suitors for the privilege of using his court, which in time of King John, that's the guy that they forced to sign the Magna Carta, the pain in the ass, when suing in the King's Court had come to be regarded as a matter of right, gave rise to a provision of Magna Carta, right? Against selling justice, which is called barratry. So that's what this scumbag was doing. He was forcing people to come and use his court and pay him in order so that they could have justice. And if they didn't pay him, they didn't get justice. So the Magna Carta, that's, I don't remember what article it is, I think it's in the 30s, and it says, "To none shall we deny nor sell right or justice." Well, damn good reason for that. It's that bastard. who's the seed line of the William the Conqueror scumbag. So, a person who desired to sue in the king's court had to obtain from the king a writ enabled to him to do so. The word writ, breve, is a general name for a mandate issued by the king or by a court directed to a public officer or private person, command to do or omit some act. The royal writs were issued from the chancery under the Great Seal. The writs by which action in the king's courts were begun were called original writs, and had at the end a what? A teste. Again, getting back to what I talked about before, the etymology of teste, or clause, signifying that they were issued in the king's name. So that's literally the king holding himself by his own nuts, saying, yep, I did this. Witness ourselves at Westminster, or at whatever place the king was, and were generally directed to the sheriff, ordering him to notify the defendant to appear before the court on a certain day to make his defense. Without the authority of such writ, the court would not entertain the case. So this gets more into process, so I'll leave this more for the aspect of the April class, but to get down here to the King's Bench. So Exchequer, Common Pleas were called collectively the Superior Courts of Common Law. So what we now have as Superior Courts of Common Law are what we, the sovereign people, decree in our Superior Courts of Common Law, where we say, nope, this is a Superior Court, I'm filing this action, because we have, and again, this gets back to more process, but I'll cover this later also in next month's class, but to make a point here, you have actions at common law. You have complaints in statutory law and equity. So complaints are over here, and actually in Maritime Admiralty you have a totally different thing. It's called a droit. So you have a droit here, complaint here, an article of court-martial here to start this thing usually, and you have a bill in equity. But I'll cover all these the rest of the day, so they'll pop up. But I just wanted to kind of lay that out there. So after the foundation of the Common Pleas, that the court had regularly jurisdiction of private suits. The Exchequer of revenue cases, meaning revenue for the king, and the King's Bench, the pleas of the crown, and private actions for trespass. But by means of two audacious fictions, the other two courts contrived to get concurrent jurisdiction with the Common Pleas over all private actions except real actions. Real actions meaning real property. A real action is an action regarding land. So just to know that. King's Bench always had the right to entertain a suit against one who was in the custody of the marshal or executive officer and was therefore theoretically present in the court. A plaintiff desiring to sue in that court was permitted to begin the suit against the defendant for an imaginary trespass and also ad ectem for a debt or other private cause of action. This was a weird thing that they did. This is actually confusing as hell, because what they did was they sued a fiction. Now, I don't want people to confuse this completely with the idea of the straw man, but in a kind of a weird sense, that's kind of what they're going back to doing. But anyway, the defendant, being then supposed to be arrested by the marshal for the trespass, could be prosecuted against for the debt. In the Exchequer, the plaintiff presented a plaint. This is not a misprint. They used to, instead of calling a complaint, it used to just be called a plaint, alleging that he was the king's debtor and that the defendant unjustly refused to pay him money which owed him and had wronged him in some other way, by which he was the less able to pay his debt to the king in the court, not permitting the false allegation to be disputed. So this is an aspect where they were kind of mixing the idea of wrongs, actual wrongs under natural law, and debts over here under the law merchant, and then taking jurisdiction. It was just, this is a story of the attorney taking jurisdiction for himself is more or less what it was. Okay. So I'm going to skip down to what gets into the basically the totality of what that eventually became. So it eventually became chancery. So this thing that they were doing with the crossing of the law merchant, with the debt and the harm, eventually became equity, which is why these three are connected. Okay. So, but the most important outgrowth of the king's extraordinary judicial authority was the equitable jurisdiction of chancery. Now this gets really weird. At the very early period The forms of procedure in common law courts became fixed and rigid. And in the course of the development of society, the relations between men grew more complicated, and a more exact adjustment of legal remedies to these was called for. No one ever questions the fact where they came from, however. And he doesn't even get exactly into what it is, but I'll tell you. So this idea of the course of development of society, relations between men grew more complicated. Okay. What they're talking about is the right of use and usufruct and trusts, which is completely unknown at common law, by the way. Now, nowadays you have people saying, oh, make a common law trust. Well, in a weird sense, there really is no such thing, in the sense of a trust of what you're talking about under Roman civil law. Now, under Roman civil law, you've got this aspect of trust and usufruct and usufructuary where they split the title. You have equitable title and then legal title. Equitable title is the ability for someone to use the thing, which then that person is then called the usufructuary, the right to use it. And then you have someone else holding the legal title, which is the right to dispose of it, which is the actual title to own it, right? And this is where you get into registry. That's where you get into registering things. So when you register something on the public records, and I don't care if it's land, car, and go to a title company, or if it's your child at the Foundling Hospital with a birth certificate, doesn't matter. You register something, you've just split the title between equitable and legal, right? So someone out there is holding the legal title and someone else holding the equitable title. Well, all this garbage under Roman civil law was unknown. It's unknown at common law. So this is what they're talking about. Relations between men grew more complicated. Well, guess what? It was the attorney doing it. Does this look complicated to you? Yeah, you're damn right. Well, that was the problem. So anyway, get off my soapbox. And a more exact adjustment of legal remedies to these was called for. Those courts found themselves unable to supply it, meaning the common law courts found themselves unable to supply this garbage. Why would they? A great many cases arose in which the common law courts were unable to do complete justice. In such cases, recourse was had to the still wide and undefined royal prerogative, because that was whatever the king wanted it to be, right? Okay, keep that in mind for a second. People who were aggrieved and could not get redress at law applied to the king by a petition, or, as it was called, a bill. So you get a bill in equity, like I said, praying for his help. These petitions the king got into the habit of handing over to the chancellor. So they pray to you as if you were a god, and then you hand it over to somebody else, an attorney. So now the attorney's God. Great. Let's see where this goes. The keeper of his conscience. Right. So the king gives his conscience to an attorney who keeps it, I guess. Yeah. Who, after such investigation has seemed to him necessary, made a proper order or decree in the king's name. Right. So basically what happened here is you have in the time of Edward III, and this guy was honestly not that bright, or he was just that corrupt, one of the two. I still don't know. I'm actually leaning probably towards both of them equally. So in the reign of Edward III, you have not only the creation of chancery courts, but you also have the laying down and the solidification of maritime admiralty courts as well in England. Both happened under this idiot. So anyway, in the reign of Edward III, an order was made that all matters which were of grace should be referred to the chancellor. And in time, the practice naturally grew up of presenting petitions or bills directly to the chancellor in his court of chancery instead of to the king. If you look around a lot of the states, guess what? There are chancery courts in our states. Why? Right? Why? Because you keep dealing with trusts and usufructuary, and you keep registering things. Stop it. You can just get rid of all these chancery courts because they'll be absolutely irrelevant, for the exception of maybe a corporation here and there having to deal with another corporation, maybe. But in early times, some applications based not upon the inadequacy of the remedy at law, but upon the defendant being a powerful man, able to defy the power of the courts, or upon the poverty of the applicant, took this same course. This is again the attorneys trying to save face, honestly. But this practice ceased so long ago that it need not be farther noticed. Exactly. Such reasons do not allow and have not for some centuries formed any ground for a resort to chancery. Well, so you get back into Roman civil law garbage and trusts and usufruct shit like mortgages and that kind of garbage. Because you see most foreclosures go through chancery court, right? Ever wonder why? You got to connect these things. Then you realize that you're in the wrong court. Okay, the introduction of the reign of Edward III of uses. Again, what did I talk about? Right? It's the aspect of use and usufruct. Now there's a note here for number 9, but it just says see chapter 30 in here. But anyway, you guys have the whole entire book to read, so you can go check that out later. So, which the courts of law would not enforce at all. Again, that's what I said. Use and usufruct. This aspect of Roman civil law filth. Courts of common law said, nope, we don't have anything to do with that. And that's just absolute garbage. We'd forget it. Get it out of here. So they created a separate court for the attorneys to do this shit. So greatly extended this equitable jurisdiction of the chancellor. A writ known as a subpoena was invented, according to some accounts, by John Waltham, Bishop of Salisbury. So a writ known as a subpoena was created by a priest who was also an attorney who was holding the conscience of the king to summon the dead before him. Anybody see a problem here? Anyway, by which the defendant was summoned to appear before the chancellor and make answer to the bill, and a regular course of procedure in equitable actions was gradually evolved. That was the priests of Baal taking back over the courts for themselves. So I will leave the rest of this interesting history for anyone else to take a look at regarding that, and we'll get down to Admiralty. Now, I know I'm going a little bit fast, common law and Roman civil law, but I want to get all these in, and but I'll finish up with Admiralty here, and then we'll take our 15-minute break. The Court of Admiralty. The Court of Admiralty is said to have been originally instituted by, again, who? King Edward III. It was held before the Lord High Admiral of England, or a judge who was his deputy, of which they became many, many more, of which the colonists were being run over by during the colonial period, and of which they'd pretty much had enough of. Part and parcel of the revolution also. There are really two separate courts included under the common name of the Court of Admiralty: the instance courts and the prize court. The former is the ordinary court, which administers the maritime law. That's where you'll get things like all the aspects of vessels and bonding, and that's your normal instance court, maritime admiralty. Prize court is dealing with actual vessels on the sea, where you take a court of prize, or take a ship of prize. But in a weird way, there's been arguments made that, and I suppose I kind of see this, there's been arguments made that when the cop pulls you over in his cruiser under an aspect of the law merchant, and that you're operating under maritime law because you have insurance on your car, which is always a maritime admiralty issue. All insurance is done under maritime admiralty, all of it. I don't give a damn if it's on the land or in the sea, it doesn't matter. All insurance is done under maritime admiralty. So we pulled you over. That is he not taking you, meaning you, the physical body, as a vessel, a prize, before a court to then sell it with a bottomry bond and condemn it? Anyway, there's been arguments made that way. I don't tend to go that far with it. I just know what they're doing as far as the administration of the estate, and I just leave it at that. I don't get into the whole, let's connect everything through maritime admiralty. Are there some connections there? Yeah, sure. Are they as important as the aspect of what they're doing from the administration of the estate and the aspect of probate law? No, absolutely not. That's always the most important thing that they're doing. So, because if you take the vessel back in probate, they can't even be over here anyway. So to continue, the former is an ordinary court which administers the maritime law. The latter is a special tribunal only existing, or at least only acting, in time of war. That again is the prize court, whose function it is to adjudicate upon questions of prize, that's the taking of a ship, the lawfulness of capture made from the enemy, and the disposition of a captured property. Okay, fine. And also vice admiralty courts in the colonies. right? That's funny. They just mentioned it in one little line there. Well, that was the problem. And again, I won't get into the rest of that. I just wanted to show you that the Court of Admiralty and the Court of Chancery both established under this guy's reign, okay? And just to get a little bit more of a historical connection here. So I'll leave the rest of this for everyone else's wonderful reading. Oh, I guess I can do the ecclesiastical courts too. So the ecclesiastical courts remain to be considered, meaning considered from the standpoint of this treatise. Before the Norman conquest, that's William the Conqueror in 1066, there were no separate church courts. Wonder why. It's because the filth of Rome hadn't been able to conquer the island, hence the Hadrian Wall, right? The wall that the Romans built all the way across England to keep the crazy Celts away from what they'd quote-unquote conquered. Anyway, so there's no separate church courts before this fool came in there. The bishops sat in the popular courts, and ecclesiastical causes were tried there. But William this is William the Conqueror, William I, forbade this, from which resulted the establishment of the ecclesiastical courts. Well, he wanted to give his filthy cult of Rome bastards, priests of El, power. So he did. The archdeacon's court is held in each archdeaconry before a judge appointed by the archdeacon and called his official, and the lowest in rank of all, is the lowest rank in all ecclesiastical courts. An appeal lies from it to consistory courts. Okay, the consistory court is the court of the bishop of each diocese. Okay. The bishop chancellor or his commissionary is the judge. The court of arches, whereof the judge of the dean of arches, also called because he formerly held the court of the Church of St. Mary, is a court of appeal belonging to the Archbishop of Canterbury. He hears appeals from all inferior ecclesiastical courts in the province. The principal official of the Archbishop of York has a similar court, yada, yada, yada. Anyway, I'm getting into the point where, guess what? Probate courts. The consistory courts were the ordinary courts for the probate of wills. So guess what? This bastard comes along, separates the spiritual and temporal courts, says there's no more of you guys getting together and ruling your own in the courts of 100. Oh, and by the way, all of the property of which gets moved from father to son, and so on and so forth, through the laws of nature and common law, an aspect of wills, are now all going to be given to the filthy cult of Rome. You wonder why we've got a problem here. Because no one is paying attention to any of this. No one's paying attention to this is where it came from. This is why you're still dealing with this shit. Why your estate is the thing being charged by a corporation in a for-profit court before a priest of El. Wake up. This is all connected, and it all needs to stop immediately. We all need to form our common law grand juries, form our courts of record, and hang them. Every single one of them. If they try to drag us over here into this bullshit. Because the founding fathers knew to stay over here, clearly, but they also knew that there were some aspects of things that, yes, in this world, running around out on the high seas, yeah, you're going to have Maritime Admiralty law. Great. So they made it very specific that the federal government, the federal courts would handle Maritime Admiralty law for all the rest of the states. So if a ship that's, registered and does business out of, South Carolina or Florida or whatever, runs into some ship that's doing business in Maine or whatever, then that's taken under a federal issue. So it goes under Maritime Admiralty. But this garbage that the ecclesiastical courts, from a standpoint, of probates and wills, and that you're literally going to these courts of Baal or Baal. That's why you pay Baal. Another etymological craziness, considering all this. This is where all of this comes from. So with that, we'll stop here for a 15-minute break. And when we come back, I'll continue the history of the difference between these courts. But what we're going to do is I'm going to open up another document of which we'll have more of a history of the process of where each of these different jurisdictions transpires and how it moves people through the courts. So let's take a 15-minute break then, and let's meet back at It'd be let's do 145, okay?